Hello again, you Mighty. Harry Litman of Talking Feds with a reaction to last Friday's hearing on a motion for contempt against Team Trump growing out of the whole Mar-A-Lago 2-year debacle. So first, I want to explain that it's all a little bit secret and it's tea leaf reading. And the reason that is there have been ongoing proceedings in the D.C. District Court, Washington, D.C. District Court, before the chief judge there, Beryl Howe, about production of and response to the subpoena that was served back in May, even before the search, for all the documents that Trump absconded with. Why secret? Because it's part of a grand jury investigation, and anything that happens in a grand jury is secret, at least until an indictment is brought. So that's why we're only kind of surmising. But we know a few clear things, and one is the Department of Justice had decided to ask the Judge Beryl Howe, to hold Team Trump and maybe Trump himself in contempt. Now, what was that about? Okay, so this is the culmination of the ridiculous cat and mouse game that Trump has put the Department of Justice to over literally 2 years. Very quick recap of the bidding. He leaves in January with all this stuff. The archives figures it out a few months later. 6 or 7 months of negotiations ensue where he stalls and bobs and weaves. Finally, he returned some about almost a year ago, and Archives finds out, holy heck, there's all this classified stuff there, and then they sound the alarm. DOJ gets involved, and it's back in May, already 7 months ago, that a subpoena was served saying, give us everything, Donald Trump. They supposedly complied with the subpoena. A lawyer, Christina Bobb, the sort of junior one in the office, it's kind of poignant. She shows up that night and, Christina, you're going to be signing here to say we've complied with everything. And she at least had the presence of mind to put in based on what others have told me, because it turned out to be flagrantly false. They didn't come anywhere close. And as that became clear, that's when the search warrant was served in August. They get a huge cache of additional classified documents, and which is a huge problem in and of itself, right? We forget about this, but it originated because there are real national security implications just to those documents being gone. And then even thereafter, the DOJ got information that he still hadn't returned everything. Probably those things are not at Mar-A-Lago, but there's been reports that he had some on planes and that people saw, and he's got a whole, they could be any of 20 places. And so there's been back and forth about that before the district court. Now, because of that back and forth, the last stage was that the district court basically told Team Trump, do a search and on your own and get everything that's left. The FBI was invited to participate in that, but that they would want no part of it. They do their own searches, and if they do it, it's going to be with their jackets and very forceful, etc. And they don't want to have potential legal responsibility if this search winds up being challenged later, even though it's his own team, by Trump. So 2 more documents, turn up in this locker in West Palm Beach near Mar-a-Lago. 2 more classified documents. And at this point, DOJ is tearing its hair out because it's at a stalemate. It believes, with good reason, there's yet more out there. And this outrageous state of affairs where Trump has played him, for chumps for almost 2 years, not returned everything. It was his responsibility to do it back in May, but they didn't and lied about it. So why can't you just subpoena Trump directly? okay, hang in here for sort of 90 seconds of law. But everyone knows the Fifth Amendment. There's a protection. You can't be forced to testify if it would tend to incriminate you. You can normally be forced to turn over documents. That's not doing anything. It's the bad information is in the documents, and that's not a Fifth Amendment problem. But in rare instances, the actual turning over of the documents could tend to incriminate you. And it's called an act of production defense. And I think it applies here because Trump is potentially going to be charged with retaining documents and having them in his possession after they've been asked for. So his mere turning them over shows that he has possession, could be used against him. So they can't, I think, just subpoena him. And everybody in Team Trump now is saying, I won't be the custodian. I won't be the... No one's going to sign to say, and they don't have to say, by the way, I promise everything's been turned up. They just have to say, I promise we really looked hard. But no one wants to go even that far, and I can't tell you how bizarre a state of affairs that is. You always have some custodian who says they did this. It can be a mob boss would have a custodian. Anybody would have a custodian, but Trump has no custodian. So at this point last week, and by the way, these two documents turned up around Thanksgiving. So finally now the DOJ, and it's a sign actually of the sort of aggressive new approach of Jack Smith, the special counsel. They said, we're going to move to hold you guys in contempt because no one is complying. So we're still sitting here 2 years later with no assurance that we have all the documents from Trump. And they went to the court to do that. The court's been pretty sympathetic all in all, pretty tough on Trump and Team Trump. But this time she said, look, I'm not going to hold them in contempt. We don't know the details, just the bottom line, but I can guess, which is she said they don't have to legally do a custodian, and nobody will do it. I can't force them to do it, and if I can't force them to do it, I can't hold them in contempt. So you have a pretty ridiculous situation where there's a stalemate. Trump still has some of the documents. They can't do a search, another important legal point, because even if they have probable cause to believe Trump has them somewhere, to do a search under the Fourth Amendment, you need to identify where it is, why you know it. It needs to be with fresh evidence. You can't just say, we think he's got them somewhere. You have to say, they're at Mar-a-Lago or they're at Trump Tower. And they can't do that. So now they're literally in a position where they may not be able to get all these documents back. And by the way, that means they can't be sure that they haven't been, Trump hasn't done something with them, given them away, sold them, or whatever. So it's ridiculous, but there's it's an impasse. But just to be clear, it's Trump may in fact be able to resist, but it still is bad for him. First, of course, it totally infuriates DOJ, not a position you want to be in vis-a-vis people who can indict you. But also the charges, if they bring them, this is a whole new layer. Even in December 2022, he refuses to produce them. They won't have a custodian. That is going to be substantive evidence that they're still withholding. So that's something that could add to the overall case against him. But in the meantime, there's this strange logjam that the district court won't break. So that's why you had these reports that they were going to move for contempt, and then the report that the judge wouldn't grant contempt. All right, bit of a complicated ride there with some legal detours, but all important to understand the implications of what's been going on. There you have it, Midas Mighty. Harry Litman, we've got our own YouTube channel. Check us out, please. But always a pleasure to come back here to explain the new bombs going off, and they don't look like they're going to be stopping. So next time it happens, you'll see me back here giving you my reaction. Till then, talk to you later.
At MeidasTouch, we are unapologetically pro-democracy, and we demand justice and accountability. That's why we're spreading our message to Convict 45. That's right, gear up right now with your Convict 45 tees and pins at store.meidastouch.com. That's store.meidastouch.com.